part of that freedom of association. It's an integral part of the right to form and join trade unions. Yes, I've also mentioned there Article 28 of the EU Charter of Fundamental Rights, which the Court of Human Rights referred to in Demir, even though, of course, the two are different legal systems. The EU Charter is a creature of the European Union, whereas the court in Demir and Ankara was the Court of Human Rights in Strasbourg, dealing with conventional human rights. But nonetheless, we see a sort of cross-pollination of ideas between the EU and the ECHR when we're talking about rights and their interpretation. So Article 28 of the Charter provides a much more, perhaps, detailed formulation of a right to collective bargaining, and it's more clearly expressed than in the sort of more implicit sense in the freedom of association guarantees. So you have workers and employers or their respective organisations have, in accordance with community law and national laws and practices, the right to negotiate and conclude collective agreements at the appropriate levels, and in cases of conflicts of interest, to take collective action to defend their interests, including strike action. So it goes much further in a more explicit way than the other conceptions that I've talked about in the ECHR and in the Universal Declaration. I should say, I actually mentioned association collective bargaining. The Oireachtas Library and Research Service did me up a paper on collective bargaining in Europe, which you'll see there, a lot of the information is very easily accessible, but it just gives a very easy guide to collective bargaining coverage across the EU member states. It's very, very interesting because the EU Charter is so clearly expressed. Article 28 so clearly expresses a right to collective bargaining, and yet we see an enormous disparity in coverage of collective bargaining from 15%, 15% in Lithuania to 98% in France. That is, of workers who are covered by collective bargaining. So it's a really interesting exercise to look at the range of different regimes on collective bargaining that they're all across the EU and all supposedly under the sort of the idea of the EU Charter, but actually very widely varied. And I know you talked, I think, in the last lecture about EU laws and EU laws relating to trade unions. Okay, but moving then to the domestic level. And what does the Irish Constitution say? Well, as you're all very aware, the 1937 Bunreacht na hÉireann gives a very diluted version of freedom of association, and there's no sense in that formula of collective bargaining. If you go back to that formula, protection of your interests, which is the implicit protection for collective bargaining. In the Irish formula, it's a much more bluntly stated, the right of the citizens to form associations and unions. That's the right in Article 46(1)(3). But of course, when you look at what goes before and particularly after, you'll see just how qualified and restricted that wording is. So first of all, so it's restricted, I suppose, in three ways. First of all, there's no reference to the purpose of protection of interests that you see in the other guarantees. It's a very bluntly stated forming, and further, I should say, no right to join associations and unions. It simply expresses a right to form. The other two ways it's restricted, of course, is the general restriction that's at the start, which is a restriction that applies to the other rights in 46(1). So the right to freedom of assembly and the right to freedom of expression are also contained in this article, and like the freedom of association, all three are restricted by the first clause. The state guarantees liberty for the exercise of the following rights, subject to public order and morality. So, there's a whole other much lengthier lecture on freedom of expression and freedom of freedom of expression, restrictions that have been imposed on that, all entirely constitutionally, from our censorship of publications laws from the 1920s onwards and so on. But anyway, so that's the general restriction that also applies to the right to form associations and unions. And finally, thirdly, you have this final clause: laws, however, may be enacted for the regulation and control of the public interest of the exercise of the foregoing rights. So it's very grudgingly conceded, this right to freedom of association in the Irish in Irish law compared to the language of the other guarantees that I've given you. So it's perhaps unsurprising, given the wording, that Irish law on freedom of association is developed within this constitutional framework in an extremely narrow fashion, with the right to freedom of association being interpreted so as to sever or separate it from any right to collective bargaining. And of course, this is a very political issue at the moment, and I'll be coming back at the end to sort of the political context. But I mean, just earlier this year we marked the centenary of the end of the 1913 lockout, and I know as part of that commemoration, ICTU and the union sought to remind the government about the lack of rights, particularly rights to collective bargaining and rights to union recognition and representation. And indeed, it's been said that Irish law may give unions the right to organise workers, or sort of, right to some right of citizens to form associations and unions, but it's neutered by the employer's right, as recently stated in the Ryanair case, not to recognise unions for the purpose of collective bargaining. And again, I'll come back in more detail to the Ryanair case. As I say, it's politically relevant and timely because just in 2011, there's a commitment in the programme for government to reform the current law on employees' rights to engage in collective bargaining, as you know, and work on fulfilling this commitment is underway. So I'll speak about that towards the end. What I wanted to do first, though, was look at the historical development of Irish law, just to try and look, and again, I'm conscious many of you will be very well aware of all of this, but just to look briefly at how the freedom of association has been interpreted in this narrow way to really remove any suggestion that it might include a right to collective bargaining, or a right to representation, or a right to recognition. What we see, in fact, is a real pattern of what's been described as libertarian or individualist interpretation of the freedom of association guarantee at the expense of collective interests. So Jackie reminded me that recently I was asked on Vincent Brown about judicial bias. And there is a clear judicial bias. It's not a bias against workers, though, because individual workers often succeed in the cases where it is a line of cases, but they tend to succeed at the expense of the collective interest. So it's unions, it's against the collective interest or the interests of unions that we see a bias emerge through the case law over many decades. And I think that's important. It's perhaps less obvious or overt than a bias against a particular class or against individual workers, but it's certainly a bias against the collective interest of workers as expressed through trade unions. So we see this sort of bias or pattern of interpretation coming through a whole line of case law. And I'll just give you a few examples. Well-known case, National Union of Railwaymen against Sullivan in 1947, which concerned Part 3 of the Trade Union Act 1941, which was brought in to try and address issues about multiplicity of unions, with large numbers of small unions. And the Act had sought to establish a tribunal with the power to determine that certain unions would have the right to organise workers of a particular class, a particular category of employment. But a group of individuals brought a case arguing that this was an unconstitutional infringement on their freedom of association. Why? Because it deprived them of the right to belong to a trade union of their choice. And the Supreme Court said that the Oireachtas power, looking at the wording, the Supreme Court accepted that the Oireachtas has power under this third clause to enact legislation to regulate and control the right to freedom of association, in other words, the right to join a union of your choice. But they said that they could only limit the ambit of freedom of association and not undermine it. And they said, the Supreme Court said, to deprive a person of the choice of persons with whom he will associate is not a control of the exercise of the right of association, but a denial of the right altogether. So on one level, that's a very kind of progressive reading, because it gives individuals an unrestricted right to join a particular union. But of course, it's a particularly individualistic approach also that says that for example, a closed shop can't operate. So it's a particularly libertarian or individualist interpretation, and certainly the public policy arguments put forward to defend the Act, the constitutionality of the Act, failed. Also well known is the case of Educational Company of Ireland against Fitzpatrick in 1961, in which a right to dissociate was held to be protected implicitly in Article 46.1, where a group of individuals engaged in picketing after the employer, the educational company, had refused to compel the employees to join a particular union. So it was about, again, a closed shop. The employer sought an injunction to restrain picketing, which is, I suppose, in the context of recent events and recent injunctions in trade disputes are very topical. Again, the High Court judgment, Judge Budd, which was upheld in the Supreme Court, he uses very libertarian language, saying that the words of the article on freedom of association, mean by implication that a citizen has a right not to form or join associations or unions if he does not wish to do so. So you can't operate a closed shop, according to Budd, because this interferes with individuals' freedom to associate or not as they please. So again, it's a very libertarian and individualistic idea about freedom of association. In Doyle v. Croke in 1988, again, a sort of very clear anti-union approach here, because the High Court here said union members were entitled to fair procedures within their union. So it was about an individual challenging union procedures, a dispute over handling of union funds. And Judge Costello said individual members must be protected against union procedures which might be unfair to them. So again, it's this idea of the individual against the collective. You then have a number of cases, in Abbott and Whelan in 1982, and then of course Nolan Transport, again a very well-known case in 1995, just being some examples of cases in which the courts have held there is no constitutional duty on employers to negotiate. So the employer is also therefore free to associate or dissociate as they please, and this means that there's no, that there can be no requirement that they would recognise particular unions. Now, having said that, there's a whole line of those cases. Most recently, Association of General Medical Practitioners and the Minister for Health in '95. But those cases, while they said an employer has no constitutional duty to negotiate, an important point is they left open the possibility that a statutory right to negotiate, a right to recognition for the purpose of negotiation, could be created by the Oireachtas. Okay, so it's an important distinction. Abbott and Whelan and Nolan Transport, all of those cases, while they're saying employers can't constitutionally be required to, there's no constitutional duty on them to recognise a union by virtue of the freedom of association of the workers, but the Oireachtas could legislate to provide for some form of requirement of recognition. Okay, so that was the position until Ryanair. Recent developments then. I suppose before we get to the recent developments, I want to start with Ryanair, but before we even get to that case in 2007, it's worth reminding ourselves that even before then, the superior courts in Ireland, the High Court and the Supreme Court, have gone to great lengths to ensure that the freedom of association would be interpreted in a very particular way, a very decidedly individualistic outlook, and generally against the interests of the collective, against the interests of the union. So we could say that Irish jurisprudence has overemphasised the individual right at the expense of the collective right. Despite the fact that freedom of association in other regimes, in other legal documents, tends to include and be inclusive of a collective right, a right to collective bargaining. In Ireland, it's been narrowly interpreted as your right to join a union of your choice or not. Okay, so that brings us then to the recent developments. And I suppose I should say, first of all, in terms of collective bargaining, I focus very much on the narrow case law, but it's important to say, collective bargaining is very much operates in a non-legal sphere too, outside of a very clear legal framework. It's usually indeed takes place in a voluntary capacity. Again, you'll all be very well aware of the voluntarist tradition of collective bargaining in Ireland, meaning that employers are under no obligation to bargain collectively with the workers, nor to recognise unions for the purpose of such bargaining. But nonetheless, bargaining goes on. So I don't want to give an impression that the law is everything here, because far from it. In fact, practice is hugely important. Then we also do have protections. Through the Unfair Dismissals Act of 1977, an employee cannot be dismissed solely or mainly due to their activities as trade union members. It's an automatically unfair dismissal. So you have protection. Workers may be represented by unions and indeed are protected if they are, but employers are under no obligation to negotiate with the unions. Now, despite all of this, again, as we're all well aware, since the late 80s we've had national collective agreements entered through the social partnership arrangement, which have covered large shares of employees and employers, and which cover pay and employment terms and conditions. And while those agreements formally ended in 2009, as we know, the public sector is still, we still have large-scale collective agreements in place there. So again, collective bargaining does go on. And indeed, in the research paper on collective bargaining coverage, you'll see that Ireland, I said earlier, Lithuania was the lowest at 15%, and France the highest at 98%. Ireland, in fact, has 44% coverage on collective bargaining, because of the public sector agreement with the unions and company level bargaining in the private sector. That's the rationale given. It's quite an interesting figure. We're exactly halfway. The other legal framework to explain about, which again many of you will be well aware of, is the that we did also have in the early years of the new millennium, and we did have legislation which attempted, of course, to circumvent the constitutional constraints. And this was agreed under social partnership. I'm talking, of course, about the Industrial Relations Acts of 01 and 04, which created a sort of shadow form of a legal framework of collective bargaining. So a union could refer a dispute to the Labour Relations Commission and Labour Court, and an employer could effectively be compelled to work within that framework. And Jerry White has said this was really a compromise solution to cases where an employer refused to negotiate with the union. But it was it seemed to be an effective compromise until, of course, it was declared unconstitutional in the Ryanair case. So what was the Ryanair case? And again, not to go into too much detail on it, but this was a case where Ryanair began the conversion of its Dublin fleet, and a number of the pilots sought to have their union impact negotiate with Ryanair because of the changes that were going to result to the terms and conditions. Ryanair refused to negotiate with this union. The case went to the Supreme Court ultimately, and Judge Gagan gives the judgment for the court. It's one of the judgments, which is by Judge Fennelly, where he concurs or agrees with Judge Gagan. And the court said that the statute work in progress, because there's a huge amount also of political issues which I haven't got into, but certainly the fact that we're in a coalition government, that Labour has been pushing very hard for some form of recognition legislation for some time, but that there's certain resistance within some aspects of Fine Gael. I know this is all on film, so and certainly there's groups like IBEC that have been very vocal, saying that this will cost jobs, and I think that's so I think while there are legal impediments, and notably Ryanair and so on, in the constitutional framework, again, the law is not everything here. In fact, I would say it's less important than the political context. And the political context is that any argument about costing jobs is going to be listened to very seriously. Now, I don't think it's true. I think there's good ways of countering that. I know Congress has put forward strong arguments about why it shouldn't, any sort of law to replace the previous framework shouldn't be seen as costing jobs. But that's nonetheless the kind of a view that's out there, and it has to be addressed as well in the political context. I hope I've left you some thoughts. I'm happy to have a discussion.
Thanks very much. You want to stay up there?
Which is what Ryanair had offered. And the union members, they said, had refused to avail of this. They said Ryanair was perfectly entitled not to deal with trade unions. And Judge Gagan gives this passage, which I've quoted pretty fully. He says, as a matter of law, Ryanair is perfectly entitled not to deal with trade unions, and then the crucial bit, nor can a law be passed compelling it to do so. So this goes well beyond Nolan Transport, Abbott and Whelan and so on, because Judge Gagan's suggesting that not only is there no constitutional obligation to negotiate, but in fact that under the Constitution, the Oireachtas can't pass a law requiring recognition. And this is the hurdle or the obstacle that is creating a political and legal difficulty, as we're all aware, in the current negotiations. So this view goes beyond pre-existing case law, and then Judge Gagan went on to say, given the purpose of the Industrial Relations Acts, they must be given a proportionate constitutional interpretation, and again, importantly, so as not unreasonably to encroach on Ryanair's right to operate a non-unionised company. So again, it's a very, it's a much stronger language about the employer's right not to recognise. It takes the individualist and libertarian interpretation a whole step further. I just wanted to give a few more points. He says the Labour Court should have seen. Gagan knows as well. If you read the judgment, he's highly critical of the Labour Court's approach here, saying that the Labour Court should have seen that there were adequate collective negotiation procedures in place through the in-house mechanism Ryanair had set up. And furthermore, he says that the Oireachtas had intended in the 01 and 04 Acts that the Labour Court jurisdiction would only be invoked where collective bargaining agreements were not in place within the workplace. So he's giving a very particular view about the industrial relations legislation. So the view goes beyond the existing case law, as I've said, because it suggests not only that workers have no constitutional right to compel or require an employer to negotiate, but it goes beyond that, and it says that the Oireachtas has no right to compel an employer to negotiate either. And so that really changed the understanding that had previously been there. The understanding was it was just a political issue that governments needed to legislate, which they did in 0104, but there was no constitutional impediment. And now we think that now it seems there is. And there's a further consequence to this, which again Jerry White has suggested, and I know that he's said this to ICTU as well, that he thinks that, on his view, there's a further and sort of even more extreme consequence of the Ryanair, of this decision, that not only may the Oireachtas not legislate for mandatory negotiation or recognition rights, but further, he says, unions then, there's consequences for unions which take industrial action in support of a claim for recognition. Why? Because such industrial action could arguably amount to an infringement of the employer's constitutional right not to be compelled to negotiate. You see that's two steps on, if you like. One step on is the Oireachtas cannot now constitutionally legislate to require recognition. The second step on, though, is that a union, therefore, is in danger of being sued for breach of constitutional rights if they are taking industrial action on a recognition issue. So again, there's a whole sort of appalling vista laid out from the Ryanair judgment, which really hasn't been, there's a lack of certainty about, of course, because this hasn't been tested. But certainly that's a very obvious interpretation. ICTU indeed has argued that there are three aspects of the Ryanair decision which strikes at the heart of the UN Declaration, the guarantee there. And just briefly, first of all, that the Supreme Court had upheld an in-house process, even though this operated under the control and domination of the employer. And the Supreme Court had wrongly seen this as a bona fide collective bargaining system, and that flies in the face of the core ILO conventions as well as the Declaration of Human Rights. That's the first one. Secondly, there was victimisation of workers, which was going on. There were threats made to the pilots about paying training costs and so on if the union was to be recognised. So again, that is in breach of ILO conventions that says workers shouldn't be victimised in this way. And then there's the point that Ryanair has this right not to operate a non-unionised company, which, as I've said, takes the interpretation of freedom of association a whole step or even two steps further. Okay, so there's many effects of the Ryanair decision, and maybe I'll move on, we can come back to it in discussions. But certainly the idea that a trade union might be in breach of an employer's constitutional rights by taking industrial action to seek recognition is, I think, a very real and worrying consequence. Okay, but of course the other consequence is that we can't therefore legislate for a mandatory recognition without a constitutional amendment, and that seems to be now the understanding of the effect of the decision. Now, I say that's an understanding. There's also, and again, I talked yesterday with Jerry White about this, because really, when you read the judgment, some of it is not, what we call ratio decidendi. Some of it is not, in other words, the rationale for the decision. In fact, you could say that Judge Gagan's words there, nor can a law be passed compelling it to do so, well, that's a throwaway comment. That's obiter, what we call obiter dictum. It's a comment that isn't directly relevant to the decision in this case. So, and further when he goes on to say they must be given a proportionate constitutional interpretation and refers to Ryanair's right to operate a non-unionised company, that wasn't strictly the rationale for the decision. So there is one interpretation that says that you could read too much into the judgment, that in fact much of what Judge Gagan says is arbiter that might necessarily be upheld by the Supreme Court in another case. But, and it certainly does go beyond what previous courts have said. So there is, I know, there's numerous senior counsel opinions, I gather, on the effect of Ryan on this judgment. I want to refer before coming to sort of the final point, just to the other two cases. And I said at the start, the troika of cases. That's not my phrase, though, although it's a very good one. It's John Hendy. He talks about the troika of cases, which he said have all but destroyed the Irish system of industrial relations. And Ryanair is but one of the three. And I just wanted to mention briefly the other two, because again, as you're well aware, these have undermined particular aspects of collective bargaining, or some aspects of collective bargaining. So until 2011, of course, we had employment regulation orders were in place under the joint labour committees, and then also registered employment agreements in the labour courts. And and the two judgments referred to there, the catering JLC judgment 2011 and then McGowan more recently in May 2013, have again undermined those systems, which were really again state-established statutory mechanisms for ensuring a framework for collective bargaining in particular sectors. Now, the JLC's ruling in the catering JLC has subsequently been dealt with through the Industrial Relations Amendment Act of 2012, which reforms the JLC system and reinstates it to comply with the ruling. However, the REA ruling in McGowan, where McGowan says this was in fact a case not about the freedom of association, but about the power of lawmaking. And it was held here in the Supreme Court that the Part 3 of the Industrial Relations Act of 1946, which set up the REA system, that this was in breach of Article 15 of the Constitution, which says that the sole power to make laws is vested in the Oireachtas. So it was really about who makes laws and were these effectively laws. They said, the Supreme Court said, registered employment agreements are instruments having the status of laws made by private individuals. So they say the REAs, which were binding agreements in the Labour Court, that these were therefore breached the separation of powers doctrine by allowing a body which was not the Oireachtas to effectively to make law. That although lawmaking functions can be delegated, the 1946 Act went well beyond that. So that has caused clearly difficulties. It's invalidated the registration of employment agreements. However, it can't affect existing or pre-existing contractual rights of workers. So those workers who are in sectors covered by REAs, of course, they remain covered by their contracts. And clearly contractual rights can only be altered by agreement between the parties. But it has very serious implications nonetheless. And I know that the TEU has talked about strike notice since the collapse of the REA system, that the union had served strike notice in quite a number of cases over pay and conditions. I think in all of those disputes they had been able to maintain agreement in the end. But it certainly has undermined significantly a huge area of collective bargaining. Now, there's legislation promised to deal with this. It's on the government's C list in 2014, which means that it is the heads have yet to be approved. The basic framework of the bill is yet to be approved, but it is due to be published in 2014. I did get a recent PQ on it from February, where Minister Richard Bruton has said that on the 7th of February he circulated a draft framework document on the new legislation. It's going to propose a mechanism where the Labour Court would undertake a review of pay and pension and sick pay entitlements of workers in a particular sector and make a recommendation to the Minister on the matter. So it's going to retain the role of the new arrangement, and this is just a framework document which has now been circulated to stakeholders and which will probably form the basis for the new bill later this year. This will therefore kind of bypass the previous route and conform therefore to what the Supreme Court has said in McGowan. So the trade union or employer can apply to the Labour Court to initiate the process, but the Labour Court won't actually make the binding ruling. It will be the Minister on recommendation from the Labour Court. So it's a neat enough solution if it can be agreed. Okay, I want to just finish so we can have time for questions with future developments. So the programme for government in 2011 stated that there would be reform of the current law on employees' rights to engage in collective bargaining, so as to ensure compliance by the state with recent judgments of the European Court of Human Rights. So that was a commitment. It's a commitment that there has been work has been done on and is ongoing on. And indeed, again, if you look at the government's legislative programme for this year, you'll see that the Industrial Relations Amendment Number 2 Bill of 2014 is on the government's A list, meaning that it should be published in spring or summer of this year. What has happened is that I gather it's at a fairly sensitive stage. What has happened, and again looking at recent PQs, is that there's been a good deal of discussion already with stakeholders, and it was in late 2012 Minister Bruton initiated the process, wrote to stakeholders to invite observations, and is still in the process of discussions. I asked his office just this week what was the position, and he's still saying he hopes to be in a position to bring the matter to Cabinet soon. I've talked to some of the people involved, and I'm told that things are at a very sensitive stage, that there's a recognition that the Ryanair decision is a major obstacle, that without a and that we have to work within that the framework of the Ryanair decision. It's clearly not going to be a constitutional referendum on this, but that it should be possible to bring forward legislation within the framework of Ryanair to recast the 2001 and 2004 Acts. First, to protect workers from victimisation, and secondly, to ensure that there's bargaining mechanisms we've put in place that are independent of management. So it's going to fall short of the formal right to require that a union be recognised in the workplace. But in some ways, I know there's different views and I'd be interested in your own views, but the US and the UK have a sort of mandatory union recognition. If you have a certain threshold of worker support, then the employer is obliged to recognise. But there's actually divergence of views as to how helpful that is in practice. That whether are unions advantaged by having this sort of process in place, that the experience in Britain has been that the process of pursuing recognition on this sort of basis may be costly, cumbersome and protracted, and the employer can use legislation not to recognise a union. So there's difference of view as to whether in fact the sort of model that we had all assumed might work, whether that would work in practice. I mean, there's a good deal of and there's a good deal of protections that can be put in legislation without going so far as to require particular unions be recognised at a particular stage. So the discussions are ongoing, and we expect to see legislation drafted fairly short. I would think fairly shortly. But certainly, there's quite a number of different aspects that have to be addressed in, and I suppose I just want to finish on that. We have to see the recent rulings of the European Court of Human Rights adhered to. We have to see our obligations under the ILO Convention, the UN Declaration adhered to, and we also have to ensure that we're within the framework, that we fall within the framework set out by the Supreme Court and the High Court in the series of cases that I've described earlier, which unfortunately does provide us with a fairly narrow definition of freedom of association. I suppose we might take heart from the fact that, as I said, even under the EU Article 28 regime, we see such a wide divergence of collective bargaining coverage across different member states. And I thought I'd just finish with the UK experience. Less than 1/3, only 29% of employees covered by collective bargaining. So, even where there is stronger legislation in place, that may not in fact give rise to the sort of increased levels of collective bargaining coverage that one might have expected. Okay, so I suppose I've left you with I hope I've left you with some thoughts.